Hi, thanks for checking out our YouTube channel here at Right Law Group. Today I wanted to touch on some issues that we see in voir dire, that's the jury selection process at trial. So if you watched our previous video about the trial process and kind of what happens, you heard me touch a little bit about jury selection, but I really want to talk to you about differences in misdemeanor versus felony voir dire processes and what you can expect. It's also important to really go over this because a lot of what people know about the criminal justice system comes from TV, movies, that kind of thing, but very rarely do you actually see the jury selection process in action. It's one of those things that, even though I believe it's the most important process of trial, it's not something that people generally know that much about. So, in a criminal trial, either at a misdemeanor or felony level, every single trial that you have that is put before a jury, you are allowed to question the jurors to see whether they are a good fit to sit on the jury panel. What happens during this process is both the DAs and the defense attorneys get to ask questions of the jurors to see whether or not they have any hidden biases, and not even hidden, but any issues in their past that would substantially affect their ability to be fair and impartial jurors. For example, let's say that you have someone who one of their family members was hit in a drunk driving accident and killed. And it happened very recently, and they are having a lot of emotional reactions to that. Now, if you're there and you're having a DUI trial where you have, for example, if my client has been accused of driving while under the influence of alcohol, I'm not going to want someone who, number one, just for the sake of being humane, you don't want to put someone through that process and make them hear all this when it's so fresh and raw in their minds. The other thing is you don't want someone sitting on your jury who's not going to be able to see the actual facts of this specific case. So what the judge always tells a juror is you have to be able to listen to the facts in this specific case and make a fair and rational decision and be impartial when you're hearing all of this. So if someone is sitting there and they're dealing with all these past emotions that they have and they're focusing on that and not focusing on the trial, they may not be a good juror for that particular case. Now, they could be good on another case where it's like an economic crime case or something dealing with issues that aren't such hot button issues for them. But that's the purpose of jury selection, is to kind of weed out the people that don't need to be on this particular jury and find the ones who are going to do a good job. And what we're looking for as a defense team is actually the same thing that the DAs are looking for, generally speaking. We're looking for people who are fair, people who can sit and listen to all of the evidence, and people who can be impartial. And the reason that impartiality is important is because at trial, all the way up until the very end, a person who is accused of any crime is completely innocent of that crime until the jury determines otherwise. Now, the jury has to be able to sit there and listen to the DA present the evidence and not make up any kind of idea of guilt or innocence in their mind at that time. They can't have any preconceived notions. They have to listen to everything fully and listen to the defense side if the defense presents any evidence in their case, and listen to the way the witnesses present the facts, listen to any kind of motives that may be present in other people testifying, and really take all the information and evidence as a whole into consideration before making any determination. What I always like to make sure juries understand is when we first get up there, my client's innocent. And when the DA is questioning people, my client's innocent. And when the DA is done, my client is still innocent. My client is innocent all the way until the jury walks back into the room and starts deliberations. Now, if they then deliberate during that process and determine that the facts have shown that they are guilty, fine, then we have a guilty verdict. But up until that point that the jury actually decides that they're guilty, my client is innocent the entire way through. And the law backs that up. So with the voir dire process or jury selection process, in misdemeanor cases, you are allowed a panel of 6 juries or jurors. In a felony case, you're allowed a panel of 12. Now, and sometimes, depending on the nature of the case and depending on how long the case is going to go, you'll actually get more than 6 or 12 people. Generally, this happens more in felony cases than in misdemeanor cases. So let's say you have a case going on. We're not going to jump to murder because that has all kinds of different issues with that. But let's say you have an assault case that's going to go on a couple of days. A lot of the times the judges will allow an alternate juror to be placed with the jury as well. So you actually have 13 people sitting in the box, but only 12 of them are going to be jurors. The alternate is the person that inevitably something always comes up when you have 12 different people. Someone has childcare issues, there's a death in the family, someone's car breaks down, and so you need to make sure that you have someone that can fill in for them if that happens, so that we don't have to do the whole process all over again. During the voir dire process, what happens is the DA gets to get up and question jurors about their background, about their history, about things they may know about the case, anything that they want to question on that's relevant to this case to see whether or not they have any issues that come up where they think that the juror either is good or bad for their side. Then the defense gets to do that. A lot of the times what I'll do is I'll tailor it specifically to whether someone has a specific motive or bias potentially against my client. So unfortunately, a lot of times things come up where you need to make sure people don't have any racial biases, make sure people don't have any gender biases, and you also have to see if they have any personal experience with the type of crime that's charged to see whether or not that's going to have an impact on their deliberations. It's kind of like what we just talked about with the person who had the family member who was killed in a DUI. You don't want that person sitting on a DUI as a defense attorney because they're automatically going to have something potentially against your client. So this process is very interesting. In the misdemeanor world, it goes a little bit quicker. In felony world, generally here in Colorado, what we have is we have jury questionnaires that when the jurors come in, they actually go to a separate room downstairs and they're talked to by the jury commissioner, and then they're divided up randomly to go to different courtrooms. If someone is sent to one of the felony divisions that has a jury questionnaire, those potential jurors, so let's say there's 40 to 60 of them, they're given this packet that the defense attorney and DA have made together before trial, gone over and everything, and then give it to the jurors, and the jurors have to sit there and fill out this questionnaire. The questionnaire asks basic demographic information, like your age, your background, where you went to school, what kind of degrees you have, what your views are on law enforcement, what your views are on general things like the charges, whether you've ever been accused of a crime, whether you've ever been a victim or a witness in a crime, kind of goes through that process. And then, before the jury is even brought up to the courtroom, then the DA and the defense attorney and the judge get to read through all these question answers to see if there's anything that just jumps out at us. This doesn't normally happen in misdemeanor cases, but it's very, very frequently happening in our felony cases here in El Paso County and throughout Colorado. All right, what the purpose and goal of voir dire is to make sure that you get a jury that is fair and impartial and going to be able to hear this case fully and completely, and make sure that we have people that are fair to both sides. So what I mean by fair to both sides is everyone has an opinion. Everyone has something that they feel passionately about. Some people are going to be more prone to be kinder to defendants in cases to understand their situation. Some people are going to be more focused on convictions, appreciating the cops and their jobs and the work that they do, and they're going to lean a little bit more towards that side of things. We want people more in the middle, people who are able to hear everything impartially. So as part of this process, we have what are called challenges for cause and peremptory challenges. Challenges for cause are if someone gets up and says, there's no way I can be impartial, I completely believe if someone's sitting there, they are guilty of the crime charged, obviously that person is not going to be fair and impartial. And the DA is not allowed to keep them on because that person has expressed a complete disregard for the criminal justice process, and we can challenge them for cause. If you are watching this video and you are looking for ways to get out of jury service, I will tell you right now, that's not a great one because we can usually see through that. I'll try to put up another video later about how to get out of jury service. Not really, that's a terrible idea, but kind of tips and tricks and things that we often see. Going back, the other challenge for cause is a peremptory challenge. Peremptory challenges are interesting. Each side has a certain number. In felony cases, usually each side has about 6 or so, where each side gets to kick someone off the potential jury panel and doesn't have to say why. So as long as it is not for a racial reason or a gender bias reason, you can't do it for those types of reasons, but you can do it because you didn't like some answer that they gave. Or I've even seen lawyers say, well, that person was looking at me mean, so I'm going to kick them off. There are all kinds of reasons lawyers use peremptory challenges, but you go back and forth. So the DA gets to preempt someone off the jury, and then the defense does. And it goes back and forth, until each has exercised all of their challenges. And then whoever is left in the box are the happy, lucky winners of the jury selection process. Those are the people that sit and hear your jury. So I know this has been kind of a longer video, but this is one of the most important parts of jury trial and things that people just don't get to know about very often. So I like to walk through it and give you an idea of what to expect and how things are going to go. If you have any more specific questions about this process, I'm happy to answer them for you. If you've been summoned for a jury, I may be able to answer questions for you. I just can't influence you in any way that's going to mess with your ability to be fair and impartial during this process. But as always, feel free to send your questions, comments, concerns, anything that you'd like us to know. You can either leave the comments below or you can contact us on our Facebook page or at www.rightlawgroup.com. Thanks.